What are the alternatives to litigation? The high cost, delay, and disruption of litigation motivate many adversaries to seek alternatives to litigation to resolve their disputes. Two popular alternative dispute resolutions, ADR, are mediation and arbitration. ADR is often faster, less expensive, and more private as compared with public lawsuit procedures. The driving force behind ADR is confidentiality. The interactions among the parties and the mediators or arbitrators can be kept confidential, as can any settlements reached. What is mediation? Mediation is simply an exchange between adversaries overseen by an individual with expertise and/or training in helping parties reach an agreement. Often, the mediator will require the parties to submit their positions and relevant documents in a premeditation brief, which is confidential and only seen by the mediator. The opposing party does not see the other side's brief. The mediator will review the material submitted and then set a date to meet with the parties, usually in the mediator's offices or some other neutral location. Each party commits to bring one or more people with the authority to settle the mediation, so that the people at the mediation can discuss the dispute and reach an agreement settling it without having to seek approval from others. The mediation typically starts by meeting with all the parties. The mediator reviews the dispute and issues that require a settlement. Afterwards, the mediator will meet with each party separately. This is called shuttle diplomacy and is used to find a common middle ground between the two sides. Occasionally, when it may appear that the parties' respective positions leave a gap between them, the mediator may make a mediator's proposal that tries to bridge that gap. If the parties agree, typically a written agreement will be signed before they end the mediation, which may be a list of terms for later fleshing out in a full agreement or an actual final settlement agreement. Because anything left to later discussion can give rise to further disputes, most mediators try to get the parties to agree to a complete signed agreement before they depart the mediation. Mediations can be conducted while litigation is pending or before litigation is filed. In the latter case, often the parties will sign a standstill agreement that promises that neither will file a lawsuit against the other on the subject matter of the mediation until they agree the mediation has failed. Overall, mediation often succeeds. District courts and the federal circuit often have mediation programs that attempt to help the parties resolve their disputes voluntarily. Because court caseloads have increased and each successful mediation is one less case that requires the resources of the court, significant attention is given to these programs. How is arbitration different than mediation? The main difference between mediation and arbitration is decisiveness. Mediations result in settlements only if all parties agree to a resolution. In most arbitrations, so-called binding arbitrations, the parties agree to be bound by the decision of the arbitrators. There is also a non-binding version of arbitration, where the parties ask the arbitrators to render a decision, but do not agree to be bound by it. In practice, these are actually mediations because they result in a settlement only if all parties agree to the result. Such non-binding arbitrations are most often used when the parties have attempted to reach a mediated settlement but reach an impasse on one or more critical issues. They may then agree to submit those impasses to non-binding arbitration, where one or more arbitrators, usually experts on the subject matter of the impasse issues, evaluate the facts as presented by the parties and render a decision. This helps the parties understand how an impartial third party looks at the issues, which often helps the parties craft a mediated settlement on their own. Most arbitrations are binding and resemble lawsuits and trials more than mediations. The parties may agree to submit their dispute to a single arbitrator, like a retired judge, but most often a panel of 3 arbitrators is appointed to hear the case. The parties may agree on all 3 arbitrators drawn from a list of suitable candidates provided by the American Arbitration Association or some other entity in the arbitration business, or each party may select one arbitrator and those 2 arbitrators pick the third. The parties agree on the rules that govern the arbitration, which can limit discovery, evidence, witnesses, and trial time in whatever manner the parties agree. Once the parties agree on the rules, the arbitration is controlled by the arbitration panel, which enforces the rules and renders a binding decision. Usually, arbitration decisions are not appealable, except in cases of gross wrongdoing by the arbitrators, but the parties can provide for appeal rights if they choose. But prolonging the resolution of the dispute by allowing an appeal is contrary to the cost and time savings objectives of most arbitrations. Arbitrations have become particularly popular for resolving patent disputes that cross international borders and involve multiple patents issued by different countries. No one court can resolve such disputes, so international arbitration with arbitrators expert in different countries' laws can fill the gap.